Good afternoon and welcome to another CSGI Speakers Series event. Thank you very much for coming. This is a lecture put on by the Center for the Study of Government and the Individual. I usually like to write this down just in case, for those of you who are not on our mailing list, you can find all our events as well as get on the newsletter mailing list at CSGI.co. Sorry, not the best marker there, but CSGI.co for Colorado. Now, CSGI exists to study the constitutional, economic, and political foundations of a free and flourishing society. And as part of that mission, we have, of course, many different areas of programming. But part of that mission is to regularly host lectures such as tonight's, which address enduring questions of our constitutional order, very much what we're doing tonight, or other parts of the framework of our society, and even contemporary problems in public policy. Today, we certainly are talking about the enduring questions of our constitutional order, how we should think about the Constitution. To help us do that is Professor George Thomas from Claremont McKenna College. He is the Burnet Wohlford Professor of American Political Institutions at Claremont McKenna in California. Professor Thomas specializes in the topics of American constitutionalism, American political thought, constitutional law, and the Supreme Court. He has written extensively on the Constitution, the founders, and the history of American education. Aside from the book he'll be talking about tonight, which is called The Unwritten Constitution, he is the author of The Founders and the Idea of a National University, Constituting the American Mind. He has also published articles on many other topics in many prominent journals. Today he will speak to us about this most recent book, The Unwritten Constitution. In it, he argues that our deepest debates about America's written constitution are not about the constitutional text, but about the unwritten ideas and understandings that guide our reading of the text. This fact, however, is obscured by the public understanding of textualism and originalism, Professor Thomas will argue. How do we weigh and balance the different textual provisions and see them as part of the constitutional whole? The text by itself does not answer all of these questions for us. So Professor Thomas will show that moving beyond the text is a critical feature of interpreting America's written constitution. He's agreed to speak for about 35-ish minutes because he wants to give a lot of time for Q&A, and I think we should have some very, very interesting Q&A. Talking about constitutional interpretation, the Supreme Court, recent decisions perhaps, we'll see. But with that, please join me in welcoming Professor George Thomas from Claremont.
Thank you. It's a pleasure to be here. So I want to first thank Professor Steve Pitts for inviting me to. You guys have a mouthful when you do this. CSGI.
Yes.
I think I could do it better if it were just University of Colorado Springs, and the Center for the Study of Government and the Individual. I direct a center. I direct a center that's called. It was founded in 1969, and I thought it had the longest title of any center, and it's called the Center for the Study of Individual Freedom in the Modern World. Kind of similar to this, but it's been an absolute pleasure to be here today. I just got a tour of, not the City of the Gods?
Garden of the Gods.
Garden of the Gods. It lived up to its reputation. I've been to Denver a bunch of times. I've never been to Colorado Springs, so it's been a pleasure. And I grew up in Salt Lake, so it's great to be back, non-Mormon. So it's great to be back in the Rocky Mountains. I do want to keep my talk reasonably short if I can, to save lots of time, because I'm happy to talk about other issues in American constitutionalism, constitutional law, American politics broadly, especially around constitutional issues in the Supreme Court. In part, there's a lot going on in our world today, maybe too much. I think my first real political moments came with 9/11, and I was like, we live in exciting times, and there's a virtue to that, but there's also a downside. And I swear, ever since then, I've been waiting for so when did the exciting times stop? When could we just go back to kind of normal life, and maybe not? But I want to to make really two simple points in my talk tonight. And I hope they're not simplistic. But the 2 points are, first, that in interpreting a written constitution, we inescapably rely on unwritten understandings to make sense of the written text. This is a feature of the written constitution, and our most important constitutional debates turn on our unwritten understandings. I'll say more about why I think it's so important to make this point in our current context, but I want to highlight and brought the book for one real reason. When I'm speaking of the unwritten constitution, I should do PowerPoint, but I'm kind of old-fashioned. Notice that the un is parenthetical. It's no doubt the written constitution is the most important part of it, but to read that written constitution, there are inescapably these unwritten understandings we bring to it to make sense of text, and I'll start to make that case in just a moment. The second part that I want to highlight, the second point I want to highlight, is that this also inevitably means that our understandings of the written constitution rest on judgments that are not themselves justified, grounded in, or determined by the written constitution. But those judgments are an inescapable feature of making sense of the written constitution. And here I'll just highlight something really quickly that I hope comes out a little bit as I go, because it's a part of the written text that we don't talk about all that often. In fact, the Supreme Court basically thinks it's off limits when it comes to actually enforceable interpretation. I mean, think of how the Constitution starts. What are its first words? Some of the students for sure know this. The students actually are really impressive in what they know today. So what are the first words of the Constitution? We the people, right? That's in the preamble. I think the preamble puts forward a number of purposes, right? To ensure a more perfect union, domestic tranquility, prosperity, right? The blessings of liberty for ourselves and our posterity, but it doesn't actually tell you how you order those particular values or purposes. It's not like it says, when there's a clash, should liberty and equality be in conflict with one another, this is how you go about making sense. This is why liberty takes preference, or why equality takes preference. So that's what I mean by we are, in trying to make the Constitution real, going to have to wrestle with judgments that we have to make, right? And that the text itself does not give us the information we need on its own to make those judgments. Now, I want to make my case by actually first going back to one of the first great debates in American constitutionalism and in American history, and that's a debate over the meaning of freedom of speech in the press in the 1790s. And I didn't pick it for these reasons, but there are interesting parallels between the 1790s and our own times, which I might get to as I go. But that's the case I want to focus on the most. And then I want to just conclude by turning to some more current constitutional issues to illustrate my point, but I want to leave most of those for the Q&A so we can talk about them then. Now, before I turn to freedom of speech in the press, I just want to take a moment to say why I think my argument is important at this time. And it's actually a book that I wrote for the public generally, that I hope is digestible by educated citizens, because it's a book for scholars, but it's a book mostly for citizens and students. And I think it's important to make the argument at this time, because I think it's not something that we fully apprehend. I think in some ways my point is obvious, but I think it's a point that tends to be overlooked. And it's overlooked in part because I think originalist jurists, like the late Justice Antonin Scalia, would too often tend to deny the point, to insist that they were interpreting the Constitution, and what they were doing was legitimate constitutional interpretation, reading the text and being grounded in the text and being governed by the text, while other approaches, those of, say, his good friend, the late Justice Ginsburg, were departures from the text, and therefore departures from legitimate constitutional interpretation. And I think this sentiment has come to frame the public debate around the Constitution and constitutional discourse, especially around the Supreme Court and interpretation by the justices. And the idea is that when we look beyond the text, we're inescapably looking to our own political preferences. I said I should pause here to say I think that sometimes progressives do themselves no services and that they actually make it sound like this in invoking certain versions of a living constitution, that it's just kind of got to evolve in ways that we can't necessarily determine. And so I think sometimes they too fall into this trap. But I want to make the point that all of these justices, right, and all of us when we interpret the Constitution, at least the parts we're disputing, that we have to rely on unwritten understandings and assumptions, right? And I want to begin by looking at a couple of the current justices because I think they really help make this point. So for instance, if you recall Justice Kavanaugh's confirmation hearings, right, he frequently pulled out his pocket constitution. I actually had mine, I left it in the hotel room, and thumbed it and said, we need to read the Constitution, we need to be looking at the precise text of the Constitution. I completely agree with him about that. It's absolutely essential and it's the place we begin. And we should be faithful to the text of the Constitution. The catch is, for so many of the questions we're most interested in, you can't just read the Constitution. Sometimes you can, and those answers are exquisitely clear. The president is, or must be, before taking office, 35 years of age. He serves 4 terms, or she serves 4 years. Senators serve 6 years. There are 2 senators. There are 2 for each state. There are 2 houses of Congress. All of that isn't disputed, and that provides really the basic framework that we work from in thinking about the Constitution, and those haven't been the subject of controversies. But when you turn to something like, what's the nature of executive power? Does it allow President Biden, without the approval of Congress, to engage in strikes against forces in Syria that we think threaten American troops? That's more difficult, right? The text doesn't say in exquisitely clear terms what goes on there. It gives Congress the power to declare war, gives the president the power to be commander-in-chief of the armed forces, but those questions require sort of more thought, and more thought that's not simply answered by the Constitution. Or take one that's going on, a case that's going on in Colorado right now. Did the former President Trump engage in insurrection to the point that he's disqualified from holding office under Section 13 of the 14th Amendment? And is that section self-executing, or does it have to go to trial? Read the Section 3 of the 14th Amendment. Like Justice Kavanaugh, I urge you to read the Constitution. You should have pocket constitutions. The Center probably already does, right? Should hand them out, as you do. But you're not going to simply find the answers there, right? I could go on. Can the governor of Florida remove the Palestinian, the Students for Justice in Palestine from being a campus group? Or does that violate freedom of speech? Another Colorado case, right? When you have liberty and equality again. Do you have to allow, if you're a public accommodation, all comers in, including same-sex couples who want, a wedding cake for themselves? Do you have to serve them? Does equal protection demand that? Or does religious liberty or freedom of speech allow you to deny them that? Those questions are not easily answered by text. Those are all important and real questions, but they're questions that we can't just turn to the text in answering. Now, those like Justice Kavanaugh, Justice Scalia, Justice Gorsuch from Colorado, say that what we do then is we turn to the text as understood by those who ratified it, right? So the idea there is that the original public meaning, as it's called, should govern our take on text. So whenever we're confronted with textual questions that aren't obvious, and those again are the most important questions we're wrestling with, we turn to the original public meaning to wrestle with those questions, and that meaning should govern us. I'm not unsympathetic to that position, and just to be clear, when we talk a lot about originalism, and this is again gets really confused, and I really want to speak more to the public part of the debate and understanding rather than the scholarly side of it. When we think of public meaning, original meaning is often confused with the idea that we should be guided by what the framers or founders said. So sometimes it's channeled as simply, so what did James Madison think? And that's what we should be doing now. And I'm going to do a little bit of that myself in a little bit. But that's actually not where most originalists are. Most originalists, and there's a really powerful argument for this, say that we should be governed by the text as understood by those who ratified it, because it's the public ratification that makes the text and Constitution binding 200 years later, right? It's law only because it was legitimately ratified by the population at one point. So that's why we should be governed by that understanding. What I want to suggest is that sounds great in theory, and I think it works at times. And I don't have any doubt that the original public meaning and even some ideas from the framers should be part of how we think about constitutional interpretation and constitutional meaning. It's just more difficult to say that it's easy to guide us because, once again, there are all kinds of judgments that we have to make on our own and that aren't easily determined by original public meaning or original understanding. And I'm going to get into that in terms of thinking about early debates about freedom of speech, but one you might just think about now to kind of highlight my point is, so do we go with the very concrete expectations and understandings that those who ratified the Constitution held? So for instance, after we passed the 14th Amendment in 1868, it's ratified by the states, and it commands that no state shall deprive any person of the equal protection of the laws. And those who ratified it thought that was entirely consistent, potentially, with segregated schools on the basis of race, or prohibitions against interracial marriage. Do we then say, okay, that was the original public understanding. We're bound by their concrete expectations. And that's the kind of originalism that Justice Scalia, at least at times, insisted upon. Now, other originalists say, well, wait, did you put in play a principle, a concept? So maybe we're bound by that principle and concept and not by their expectations. So even though they might have thought that racial segregation was perfectly consistent with equal protection, as they understood it, we now know that that's not the case. Or even though they didn't expect equal protection to apply on the basis of, say, sex or gender, that doesn't matter because, of course, equal protection must apply in those terms. And so then you get debates about, say same-sex marriage protected under the Equal Protection Clause. My point, again, is I think that those are all interesting debates, but again, the text and original meaning aren't going to simply settle the issue. We're not going to escape having to render our own constitutional judgments about that again, are not simply justified by way of text. And before, again, my last point, just in terms of setting up why I think my argument is important here, I think originalist scholars would say, yes, this is right, this is true, but it's a point that I think is obscured by the most prominent judicial advocates of textualism and originalism, and I think that in their view, and especially in how it's treated in Congress and by representatives, there's a tendency to merge textualism and originalism together and to deny the unwritten understandings and assumptions that they're working from. And that's what I want to make visible tonight. So let me start now by turning back to 1798. And some of you might be familiar with this debate. Others might find it pretty surprising. So in 1798, Congress passed and John Adams signed into law the Sedition Act of 1798. The debate that surrounded this law was a profound debate in American constitutional history. It really was a debate that forced citizens, representatives, members of the court to wrestle with fundamental questions about the very nature of Republican government, or liberal democracy or representative democracy, as we might now call it. And those debates informed how they understood the written Constitution. It was a debate about how profound the changes in the American political order were from the earlier British inheritance. And so just to start with some understandings about that inheritance. When the Sedition Act was passed, it prohibited, made it a crime, punishable by fines and jail time, to speak false, scandalous, or malicious things against the government with the intent to defame it or bringing it into contempt or disrepute. It basically took what was called the crime of seditious libel under the common law and turned it into a statute and aimed it against not just the American public, but other political figures. So if you think of what seditious libel is, the idea is that your speech against the government, you're defaming the government, you're criticizing the government, right, is equivalent to sedition because you're undermining the government. You can be put in prison for undermining the government. And so the Sedition Act of 1798 took this understanding and made it a crime for people to criticize the government. The catch was, and this is an important catch, unlike the traditional definition of seditious libel, truth was actually a defense at the time. Now, I mean, this seems really kind of weird, right? Because if you think about it, it's like, well, if what I'm saying is true, then shouldn't that, of course, be okay? Actually, under the common law, truth made it worse, because if what you were speaking was true, then you were really defaming someone, right? So if what you were saying about the government was true, you get even more trouble for it because, right, put in prison for it, because it would bring the government into even more disrepute. And so really what this argument is about is, do the people, do other government and public officials have the right to criticize those in power at the time and willfully try to bring them into disrepute? And when we think of something like, is truth a defense, right? What do we make of truth being a defense? How do we understand whether certain political opinions are true or not? And that becomes much of the debate. Now, the question at the time, right, was pretty simple in textual terms. The First Amendment, right, passed in 1791, so ratified by the public in 1791. 7 years later, you get the Sedition Act. So mine should be pretty fresh on this, right? What is the original public meaning of this at the time? But the words are pretty clear in the First Amendment, right? The First Amendment commands that Congress shall make no law abridging the freedom of speech or of the press. There was no disagreement about what the text meant, right? I mean, I'm sorry, there was no disagreement about what the text said. Everybody agreed the text said. The question is, what did the text mean? What was this concept of freedom of speech and the press? How were we to understand that? So the debate that ensued was really entirely over in a small R Republican government, in a liberal democratic government, in a government grounded in popular consent. How are we to understand freedom of speech and freedom of the press, right? The text points to a concept that has to be situated in political, historical, and philosophical terms. Now, what might surprise you at the time is that the defenders of the Sedition Act said it was perfectly compatible with freedom of the press and freedom of speech. In fact, while there was not a Supreme Court decision handed down on this act, there were a number of justices, the justices used to sit, probably unconstitutionally, on circuit courts, right? So that meant that they sat on the Supreme Court and they also sat on the lower Court of Appeals. That meant they, as Supreme Court justices, they often heard their own cases that they decided as appellate justices, which is part of the problem. But a number of justices, and I'm going to get to them in just a moment, sat on lower courts that heard these cases. It's almost certain that if the Supreme Court had heard a case at the time, they would have upheld the Sedition Act as constitutional, and that they would have thought that it was perfectly compatible with the freedom of speech and the press. And one of the things I want to kind of push you to think about in this, and it's part of my other constitutional work, is here we have a debate where ordinary citizens, members, James Madison was a member of Congress, he's a future Secretary of State, President, kind of important in the Constitutional Convention, but he's an ordinary citizen in 1798. He's no longer in Congress. James Madison is a citizen, other citizens, journalists, actually push a meaning of freedom of speech that we come to accept, right? And that we come to accept it because we think it's essential to a Republican or Democratic political order. And we think that against justices who would have enshrined a very different understanding of freedom of speech. So one of the things to think about as I go is you're also witnessing, and this is where there are maybe similarities between our day and the 1790s, you're actually witnessing the birth of political parties. I mean, they are polarized like we are in the 1790s, right? So much so that they think that you're going to lock up your political opponents, right? John Adams was short and he was thin-skinned. You could actually even imagine John Adams doing things like tweeting fake news, right? Could definitely be something John Adams would do. I think maybe the parallels with that other president and there in some ways. But John Adams doesn't. John Adams, just to put it in these terms, John Adams does not actually attend the inaugural of Thomas Jefferson in 1801. When Jefferson does, on March 4th, take the oath of office, John Adams is on his way back to Massachusetts. He doesn't want anything to do with this peaceful transfer of power at that time. But right, John Adams has thin skin. John Adams thinks that you can lock up your political opponents. What you're witnessing on the part of the small d, small r Democratic Republicans, the Jeffersonians, the Madisonians that I want to get to in a second, they're arguing that actually political parties have to be an essential feature of this new form of government. We didn't really have parties before this started, right? So you're also witnessing the birth of thinking about contests between different parties, serious dispute between the government and outsiders at the time, but all done in a way that's supposed to remain peaceful. Right? And so part of what I want to highlight here is I think those ideas are actually in the process of being constructed. The ideas we understand about freedom of speech, political parties, are in the process of being constructed because the question is forced on the political community. So it's not simply a matter of looking back at the text and saying, what does this text tell us what to do? Because in a real way, the text doesn't answer the question for us, even when we turn to something like original public meaning, because there's almost no debate, believe it or not, over the First Amendment. Right? The whole Bill of Rights doesn't really have a great debate around it. There's no great debate that says, well, what do you think the Fourth Amendment means? Or what's the First Amendment? How did they understand that in Virginia? There's very little of that kind of information. And so this is the first real debate about that. Right? So let me start with how this is defended by Supreme Court justices at the time. Now, they're not, remember, sitting on the court, but they're Supreme Court justices. And you have Federalist justices like Samuel Chase and James Iredell, who insist, following William Blackstone and the common law understanding of freedom of speech, that punishing speech that defames the government is perfectly compatible with the freedom of speech and the press. Samuel Chase, and this is where maybe there are also similar parallels to our own day, Samuel Chase was actually the only Supreme Court justice to ever be impeached, but he was not removed by the Senate. It fell short by a few votes, and some of what I'm going to read to you about Peach is grist for his impeachment. So Jeffersonians thought he should have been impeached, and there's an argument that we've used impeachment much less than those who framed the Constitution ever would have imagined. That they probably thought that occasionally you would impeach a Supreme Court justice, a member of the executive branch, or a president, right? Whereas we've never removed a justice or a president by way of impeachment. But so when they turned to the common law jurist Blackstone to gloss the meaning of freedom of speech, both Chase and Iredell, and almost every other Supreme Court justice, with the exception of James Wilson, thought that seditious libel, the Sedition Act, were compatible with freedom of speech, argued that a licentious press was actually particularly harmful to Republican government. And it was harmful because, as Chase put it, it would corrupt public opinion and destroy the morals of the people. So it was imperative that such speech be punished in order to protect the government. Now, Chase acknowledged the importance of elections to Republican government. But once the election was over, Chase argued that the minority must surrender up their judgment. In fact, he made this argument in a case where Thomas Cooper, who was tried under the Sedition Act for his serious critique of John Adams as president, and he compared Adams unfavorably to Washington. He said Adams was trying to get us into a war that we shouldn't be getting into, and Chase went out of his way to say, I want to defame John Adams. I don't think he's suited for the office. And Thomas Cooper was his own counsel at trial, defending himself in these terms. But Chase told him that it was not for him to speak illy of John Adams. That John Adams had been elected, and once John Adams had been elected, it was the job of Thomas Cooper and all other citizens, including people like Representative Gallatin, who later becomes the Secretary of Treasury under Thomas Jefferson, to acquiesce and be quiet. So there's this interesting thing going on with Chase and Iredell and others. They know elections are important. They insist on Republican government, that is popular government. They know that people have to have their say, but then they say, okay, but we've had the election. You get the election, and now once the election is over, then the minority, the opposition, as we would now call it, the loyal opposition, as we now call it, actually, right, would have to acquiesce to the government and couldn't indulge in criticism. And one of the things they don't wrestle with clearly is, so when are you going to start up criticizing the government again, right? Because there's and you have 1798 is the Sedition Act. There's an election that's going to be held in 1800, right, between Jefferson and Adams. So do you get to start like criticizing the government again in September or October, right before the election? Chase doesn't wrestle with these things, but the point is, he thinks it's perfectly fine and lectures the juries that it's perfectly fine to punish people for their speech. I mean, the real argument in the end is that freedom of speech under the First Amendment would really only protect people, newspapers, citizens from what's called prior restraint. Because it used to be that in Britain that you had to get approval in advance to publish something, right? And the idea was that was unacceptable. It becomes unacceptable even in Britain. And so there can be no prior restraint. You can publish whatever you want, but you can be punished after the fact for the things you say. So Chase and Iredell say, following, again, the common law jurist Blackstone, that that's perfectly fine, that no prior restraint is the rule, but once people have spoken, you can punish them for their speech, even if their speech is aimed at mostly framing political opinion. One of the things I want to get to in just a second is, so how do we make out a difference between our judgments, facts, and opinions in some cases, right? So Chase goes on and says, to persistently criticize the government with the improper motives of influence the public against it is unacceptable. And he charged the jury in one case, this is in Cooper's, where he says, criticism of President Adams made with the intent to bring the president into contempt and disrepute and excite against him the hatred of the people is punishable under the Sedition Act and totally consistent with freedom of speech because it's not constitutionally protected speech. And so it did not matter, Chase said, if his opinions were true. Once the government was in power, it was the people's place, the citizens' place, the journalist's place to acquiesce. Right? Now, other newspaper writers, Thomas Cooper for one, he was actually a graduate of Oxford and an immigrant to the United States. But ordinary people in bars, there's one instance where a citizen in a bar in Massachusetts is having a beer and he's going off on John Adams, and he doesn't like John Adams, and his fellow citizens turn him in, and he is punished under the Sedition Act. He's fined and sentenced to like 9 months or a year in jail. Some of the prison sentences that I'll get to in a second go up to 4 or 5 years. One representative, Matthew Lyon from Vermont, is actually reelected from his prison cell. So he's found guilty, he's put in prison for this, and he's a representative, and he was critical of the government, critical of John Adams in particular, but then has a campaign, gets elected from jail, and yes, I know what you should be thinking. There's nothing, you want to go to the text of the Constitution? It doesn't say a word about whether being in jail makes you ineligible to hold office. So, right, there's precedent for that. So he's elected from jail. So you have ordinary people, journalists, but you also have people like James Madison, who I'm going to focus on the most, making the argument that this is actually profoundly unacceptable. That this understanding of freedom of speech might be the British inheritance, but it's radically different from what would have to be acceptable in America. And so Madison argues, and again, right, he's a couple of years away from being Secretary of State. He's been a framer at the Constitutional Convention, probably the most important one at the time, and a representative from Virginia, but he's no longer in office, although he's working with Jefferson in the creation of what becomes the Democratic-Republican Party. But Madison argues free speech has to have a new meaning in America. It can't punish speech that's unacceptable to the government. And he says it doesn't matter that truth is a defense. And he's going to point to some of Chase's trials to show why that's so. But Madison's argument is that the foundations of the Constitution reflected a revolution in government. Right? So the nature of Republican government has to be understood as allowing for wide criticism of the government in power. Right? Not just the government generally, but especially the people in power. And Madison wants to argue that this is absolutely essential to the idea of Republican government. And so, like Chase and Iredell on the Federalist side, Madison and the small r Republicans are reading the text of the Constitution, right? They both insist, the Congress shall make no law abridging the freedom of speech or the press, and they're both saying we have to understand that text in terms of small r Republican government, but their understandings of small r Republican government are profoundly different, and that's what leads them to profoundly different understandings of what the freedom of speech and the freedom of speech of the press protects. And so Madison's argument is the common law inheritance cannot be the American idea. He says that the idea of the freedom of the press can never be admitted to be the American idea, because the common law inheritance is simply at odds with the idea of popular government. And Madison insisted this was because of essential differences between the British Constitution and the American Constitution. Madison argued in the American system, power flows from the people, which requires a much more robust conception of freedom of speech, allowing the people, the popular sovereign, as he argues, to criticize the government, which is bound by the Constitution. So it's the government who can't engage in this. Now, I want to pause for just a moment, because part of the argument that's just important to kind of understand is that if the Federalists at the time, especially in the figures on the Supreme Court, are arguing that truth is a defense, as you can imagine from the trials that were happening, right, they were rarely debating the truth, right? In fact, remember, Samuel Chase lectures the jury to ignore that Thomas Cooper thinks his opinions about Adams are accurate, because he says it doesn't matter if he thinks his opinions are accurate. He has to acquiesce now that John Adams is elected. So it's not for him to criticize John Adams. Madison's point would be that even if you're trying to say that facts or truth make a difference, right, too often it's going to lead to the criminalization of differences of opinion, because we can't easily always distinguish between fact and opinion. And I want to give you a couple of examples of this. And this might hearten you, again, if you think of our own times, right? If you think the press is bad in our day, and if you think we're polarized, right? We were there before in the 1790s. So this is the Democratic-Republican press at the time, right? They called Adams a liar, whose office was a scene of profligacy and usury. He was a hoary-headed incendiary whose hands are reeking with the blood of a poor, friendless Connecticut sailor. Right? Now, Madison's point was, so wait, how do you determine the truth of that statement? Right? Was Adams a hoary-headed incendiary? right? Was it a scene of profligacy and usury? And some of this is just invective, right? But John Adams was thin-skinned. Again, John Adams would be fake news all the way, right? You could imagine John Adams doing that. You could imagine John Adams texting. That might be a little bit of a stretch, but I don't think, what's the word on like text limits? It's like 240 words. John Adams couldn't put it that briefly. But, right, there are real questions here. So, and this was Madison's point about opinion and truth, right? He was called a liar and a hoary-headed incendiary because they thought he was actually trying to provoke war. They thought he was going to war with France. And they thought he didn't have the power. If you go back to Thomas Cooper, right, the journalist educated at Oxford, all of his arguments and his own defense and trial were like, Adams is driving us to war with France. I think that that's wrong. I think, and he goes on about Adams's poor character in saying that he's doing this. And he's saying he's acting like a tyrant. And I think he's acting like a tyrant. And Chase is like, you can't say that. So how do you make that judgment? Is he a tyrant? A fact? Is it a political opinion? Can you punish him for saying that? But it gets more serious when we say, hands are reeking with the blood of the poor friendless Connecticut sailor. One of the issues at the time that really divided Federalists and the Democratic Republicans was, a kind of quasi-war with France, and then the fact that Britain was engaged in the war with France as well, and they were, in the process of doing that, taking sometimes people who Democratic Republicans wondered were American citizens and impressing them into the British Navy. And so there was a real question in one case about a citizen from the Democratic Republican perspective that Adams turned over to the British. Adams said he's a British subject and therefore I have to turn him over. The Democratic Republicans were like, we need due process. You can't just say he's a British subject. We need to have a trial. We need to have some kind of due process to make sure that he's in fact a British subject before you turn him over. Adams didn't give any of that. So when they say he's a hoary-headed incendiary whose hands are reeking with the blood of the poor friendless Connecticut sailor, right, there's a real political issue underlying that. And Madison was like, how are you going to sort out the opinions from the facts or the truth in that case, right? So the Sedition Act is just going to open the door to criminalizing political opinion. Now, the Federalists were just as engaged in this sort of thing. So again, think of the press in our age. According to the Federalist press, the Jeffersonian Republicans were the refuse of nations and frog-eating, man-eating, blood-drinking cannibals. Now, the refuse of nations was real because one of the things that was going on at the time was also the Alien Act. And the Alien Act limited who could come into the United States, and if you were already in the United States, even if you were lawfully in the United States, it limited the kinds of rights you had, right? Federalists said, we need to do this to defend the character of the nation and who can come in to the country. We don't want to accept the refuse of nations. And the Democratic Republicans were saying, wait, these are immigrants coming into the country and they have the same rights now that they're here that other Americans have, right? There's no distinction between them. So that was a real debate going on at the time. Again, right, put in inflammatory language, peppered with lots of opinion, but how do you draw out the facts from that? When you turn to the blood-drinking cannibals, I have to say, I've wrestled with, I don't know if there's something real there. Other than, the closest thing is, the French Revolution was going on at the time, and the Democratic Republicans are siding with the French in this, and the Federalists are, saying, look, we're worried, they're eating their own, which could be the, blood-drinking cannibals. But the frog eating is a reference to the French, and the fact that the Federalists didn't like the Democratic Republicans siding with the French. So there are real issues here underlying these arguments. And Madison's point was, and it's made, again, I'm focusing on James Madison, but the point is, ordinary citizens in bars, journalists in newspapers, representatives, whether it's a Gallatin or a Matthew Lyon, are also making these kinds of arguments. And they're making arguments, I want to suggest, that are trying to build out constitutional understandings. I don't think their understandings of freedom of speech were just latent in the document, waiting to be brought out. We had debated free speech a little bit before, and we had agreed to protect our freedom of speech. The problem is we had profoundly different understandings about what that protection entailed. And I want to suggest that an event like the Sedition Act of 1798 forced the political community to wrestle with what we thought the freedom of speech would have to mean. What would it mean to take popular government, Republican government, seriously? What would freedom of speech have to look like in those terms, right? So textual meaning was being constructed from the political theory that underlies the constitutions, right? Arguments against the Blackstonian understanding of freedom of speech in the press were creating a Republican government rooted in individual rights and popular sovereignty, and a government that would provide for robust political dissent against the sitting government. And if you think of Madison's argument at the time, he's actually best understood as trying to create a political party that would embrace these understandings and bring them out, right? Constructing constitutional meaning for him as part of the development of Republican principles and Republican ideas. And so a couple of the things, and then I'll wrap up with this, a couple of the things that are important, I think, that come out of this are precisely that when we think of freedom of speech, right, we really take for granted, of course, you can criticize the government. What would it mean to have a popular government where a citizen couldn't attempt to defame those in power, right? To bring them into disrepute if the citizen thought that they should be brought into disrepute, right? Or to insist that what they were doing was wrong or unconstitutional, right? Or just dumb and bad policy, right? We take that for granted, but we take that for granted because an earlier version of our political order and citizens actually had a debate where they thought through these issues, worked them out, and came up with this understanding, right? And we really inherit their understanding, but also going on here are other things that we take for granted, right? I mean, when you think about the election of 1800, right, that comes out of this, it's the first peaceful transfer of power in a modern constitutional government where you're getting the beginnings of an opposition party that's trying to organize citizens who are persuaded by its understandings, and they're loyal to the constitutional order, but they disagree profoundly with those in power, right? The other political party. And you get the emergence here of political parties where when we're trying to work this out, how can you be loyal to the constitutional order, but profoundly critical of the party in power, right? The sitting government. And we're working this out at the time. And so here, again, something we take for granted, right? Not just the peaceful transfer of power, but the idea that the political opposition, right, is not the enemy, right? You're opposed to them, and you're opposed to them for all kinds of profound reasons, but you can both be loyal to the constitutional order, even if you have potentially different, sometimes profoundly different understandings of parts of it. And so that's coming out at this time. And my point is that when we think of debates like this, and I'm only using this one, I'll turn to really quickly to a couple of others, just in contemporary terms, right? That this was among the more important constitutional debates we had. Pause for a moment just to think, it didn't involve the Supreme Court at all, right? And too often we're preoccupied with the Supreme Court when American constitutionalism is much broader than that. When it did involve the justices were, in most of our understandings today, wrong on the issue, and it was other political figures that have put forward ideas that most Americans, and I think rightly so, accept today. And I want to suggest that that's really part of how we should think about constitutional interpretation and constitutional meaning, because again, on some of these most important questions, right, the text isn't the obvious place to answer them. Again, it's the place to begin, and we want to make sense of it, and we have to think about it, but we have to turn to history, to the principles and concepts underlying the text to really make sense of it. And let me just end then by saying, kind of quickly, I think this is also something that we have to do in our current constitutional debates. And again, whatever your persuasion, all justices on the Supreme Court do this when it comes to how they understand the Constitution. I think they have to make judgments that aren't justified by the text itself, but really rest on, right, their understandings about the best reading of that text. So take just, one quick example from voting rights a few years ago, where you had a really interesting and important clash between Chief Justice Roberts and Justice Ginsburg. Justice Roberts held sections of the Voting Rights Act of 1965 as applied in the early years of the 21st century as unconstitutional. And Roberts said they were unconstitutional because while certain states had to get pre-clearance from the Attorney General's office before they could make changes to their voting rules, the evidence and empirical data that Congress was drawing on to make that distinction was all drawn from the 1960s. He said that would need to be updated in the argument. So Roberts' argument was federalism is the idea that states have to be treated equally, and while we're treating them unequally here, it might have been justified in 1960, but in order for Congress to do this in the early years of the 21st century, they would have to provide new evidence. And my point is that I think Roberts is making a perfectly powerful argument, but what he's really doing is saying federalism is the thing that should really be driving our understanding here, and I think that's perfectly reasonable. Dissenting, Ginsburg was saying, but wait, this has worked really well. We don't have any problems with this. Congress just renewed this, and it secured voting rights for those it once denied, namely black Americans. So why would we get rid of this now? She said it's the equivalent of throwing out your umbrella during a rainstorm. And Ginsburg emphasized, in contrast to Roberts, not federalism, but voting rights and voting rights for minorities. I think that those are both plausible readings, right? Their argument is not really on the text. It's how to weigh and balance the different constitutional provisions and fit them together as a whole. And I want to suggest, and I'll leave those for the Q&A, but I want to suggest that we do this in all kinds of cases, right? Because go back to the preamble again, right? The preamble gives us the broad purposes of the Constitution, but, right, it doesn't tell us, what do you do when liberty might conflict with equality? Does prosperity come before liberty in that ordering? How do we make the Union more perfect? What if making the Union more perfect comes at the expense of other things? How do we go about ordering our constitutional principles and values? And the text doesn't give us that information, right? I mean, so we have to, based on our best understandings, make sense of the text in that way, and I don't think that we can do that just by turning to text. We have to be honest about the judgments we're relying on to make sense of text. And I want to suggest, and this will be my concluding note, that this is the very essence of constitutional self-government, right? That it really requires of us as citizens, not just representatives, and certainly not just Supreme Court justices, but it requires us as citizens to make these judgments and to engage the Constitution at that level. Thank you very much.
Okay, so we have about 15 minutes for Q&A. We do not have a microphone. I'm going to let Professor Thomas call you out, but since we don't have a microphone, please speak clearly and loudly enough for everyone to hear. And I will let you, Professor Thomas, call out questions.
Thank you for being here, sir.
Thanks for coming.
So I want to read from your book here, just one thing. So alone the text does not answer many of the constitutional questions. Alone the text does not answer many of the constitutional questions we are required to wrestle with. So where do we turn? My question is centered around the courts. And so you mentioned that the textualist, the originalist, like Antonio Scalia, would say if it wasn't with the text, if it didn't answer the text, which it's only an 8,000 word document, so it's probably not going to answer everything all we're going to wrestle with. If it doesn't answer that, then the litmus test is go back to the meaning of who ratified it. Right? So my question is there a litmus test though then, for lack of a better word, for those who say it's like your point, it's more unwritten. So where do you go to prove, if you will, your unwritten theory, I guess?
No, it's a good question, and I, in the book I actually duck it because what I want to point out is and this is the bigger point I think, and then I'll get to where I would go, because I'm actually in agreement with Scalia in many ways, but see, Scalia goes to unwritten understandings first too, right? Because when Scalia says, okay, so we turn to original meaning, why? Right? That's not a textual principle. Right? He wants to turn to original meaning because he thinks it actually limits the discretion of judges. That's a perfectly good thing to do, right? But that's also not a constitutional textual provision. That's based upon his theory of what justices and judges should do and his understanding of democracy. So, right, Scalia's already made a bunch of judgments that I think are perfectly defensible, but they're grounded in his unwritten understandings, and he's reading the text through that lens, right? So then he says, you get to something like rights, and he's like, look, for instance, and Scalia is a powerful thinker and an elegant writer. So when it comes to something like, do women have a right to terminate a pregnancy, right? Is abortion a constitutional right? He says, no, and I know this for two simple facts. The Constitution says absolutely nothing about it, and we've prohibited it in history, right? And that's a powerful argument. But again, the text is read through those kind of unwritten understandings that Scalia has. And when you turn to something like interracial marriage, though, you could say the same thing, right? And say, but wait, the text says absolutely nothing about it. And long-standing history and tradition have allowed for the prohibition of interracial marriage. It was only in 1967 that the Supreme Court in Loving v. Virginia said, right, you can't prohibit that under the Equal Protection Clause. That's pretty late in the day. Right? And Scalia is like, no, but that's right. And so my question for Scalia is like, where are unwritten understandings sometimes powerful and good, and sometimes why are they, he's more skeptical of them. So what I want to do is make visible that we're all going to have to rest on those judgments. And so I'm with Scalia in terms of, I think turning to the history is absolutely essential. I think it helps us understand what were the purposes of the constitutional provisions we're trying to understand, and why historically were they there. From there, I guess I would say, where I would be, I think, quite different than a Scalia, is I'm much more skeptical of being bound by the particular concrete understandings put forward. I mean, when you think of, we start with we the people, right? But we the people is a different people in 1791 than it is in 1868 or in 1985 and on down the line, right? I mean, so if we can understand the concept they brought into being, the idea they brought into being, or the principle they brought into being, I think we then have to think how should we understand that? And this is also where I would be somewhat different, I don't think we're just unlocking some past meaning. Right? I think we actually have to kind of wrestle with it in our own concrete terms and think through it. And that's where I get it. It's like that part is like, okay, but that's just a lot of like kind of judgment that's like political argument generally. I actually think that's right. But I think there's no safe space. There's no ground that's going to get you away from that, because I think even originalism doesn't really, because again, they're like, there's the famous line about like how the earth stands on a turtle. And then, Bertrand Russell asks, the philosopher Bertrand Russell asks the woman, well, what does the turtle stand on? And she's like, well, it's turtles all the way down. It's just those kinds of judgments all the way down. And I guess that can be kind of scary, but I think that's where we are. Are you saying maybe there's a time to have an open discussion about some of these amendments now that we're in future generations? I think we should for sure. A debate about the 14th Amendment, the due process and the... Yes, I think we'd probably be better off with more constitutional debate from citizens and our representatives, and we can come to understandings, right? I mean, like in 1790, they were polarized, they were divided. I think the understandings they came out in 1790 are pretty powerful and resonate to this day. Yes.
Remind me the name of your book, please.
Oh, the unwritten Constitution, parenthetical on. Because the written Constitution is where you go. I do not think we just abandon it and say like, oh, the Constitution can mean whatever we want it to mean. I think that would be wrong. I think there are readings of it that are way out of bounds, and we can kind of rule those out. But then there are these more difficult questions that we have to wrestle with as a society.
I guess it's kind of cynical for me to view it this way, but like looking back on the Sedition Act and looking back about how the justices viewed it and how looking back we would view that as wrong. I guess my question is, with this kind of two interpretations of the unwritten Constitution, why should I not think 100 years from now, I'm going to, like, whoever is living then is going to look back and think that what the Supreme Court justices are ruling on right now is wrong, right? And I guess to me, it kind of, like, lowers the importance of the Supreme Court when looking at it that way, because there is two ways to interpret the unwritten Constitution. I guess why should I believe that they know what's best about the Constitution, or rather that in 100 years they're not going to be wrong?
No, that's a good question. You're not cynical, right? But the idea, okay, but the idea, and I have great respect for the Supreme Court, but the idea that the Supreme Court would be right all the time also seems, doesn't that seem troublesome? We've got to know that that's wrong. And so, I think there's an argument, should you, and actually, to Scalia's credit, Scalia often thought there were issues the Supreme Court simply shouldn't decide because they were hard and difficult, and if they're that hard and difficult, maybe they're just best left to democratic debate in society, and I think that's a powerful argument, and then you can have maybe a smaller number of issues that are going to be decided by them. So there's a great question, what's the benefit? And there have been great benefits, and the court has had moments where it's, protected constitutional provisions against a Congress who would overstep them, or a president who would, and protected individual rights when society was, willing to overstep them. So, but I would say, the idea that the Supreme Court is a font of sort of truth in constitutional interpretation is something I'd be skeptical of. Right there's a kind of version of this, that there's a Catholic version of how you think about constitutional interpretation. I say this actually as somebody who comes from a Catholic family in Mormon, Utah, that you think of the Supreme Court as the Pope, and they tell you what the Constitution means, and then everybody just follows that. Or there's a much more Protestant version, which says the Supreme Court's an important part of thinking about the Constitution and it decides cases, and it's sometimes it's right, sometimes it's wrong, like everybody else, but everybody has an obligation and a duty, especially other political officers, to interpret the Constitution on their own. And that part is what gets eclipsed. And if you actually think of some of the more important figures in American political history, Abraham Lincoln, he engaged in serious constitutional interpretation, often against what the court had said. And so I think, that's it's not to disillusion you about the court, or say that you shouldn't trust the court or think that it's wrong, but it's to say we should think actually about what the court's saying and doing, and we should then engage them on that, and our fellow citizens.
Returning to the freedom of speech, there is a part of, and I believe it's in the Constitution, that says that the citizens have a right to peacefully petition.
Yeah, they have both.
But the peacefully part seems to be lost now.
Yeah, so that's fair. That's another one, right? You have a right to petition the government for redress. And petitions are actually a much bigger part of constitutional history than we think. Like, people actually used to write the government much more often, and there have even scholars who collected them, and you'd think, don't know if I want ordinary citizens writing the government, and what are they saying about constitutional questions? And actually some of them are really interesting and smart, and that's more of a formal petition, right? Yeah, but you have a right to peacefully assemble. There's an argument about that, and I think that's one of those areas, right, that so think about some of the first questions I raised, like when you think about free speech on campuses these days, what happens if it's not peaceful, right? Is blocking a speaker a peaceful form of protest or not, right? That's where we have to then debate what that means. And I'm of the side that I don't think you actually can block a speaker. I think that's actually oversteps your rights, because then you're also blocking somebody else's right from seeing that speaker, but you can certainly protest them outside and in. But that's something that we then maybe need to recover. Yes?
So I've got a question. mentioned judicial discretion. And I was curious of how you saw you can impose some sort of a limit to that judicial discretion with an open interpretation. To me, it seems like your originalist acts as that limit, and then you have the opposing view as well, where it's a living document. So you have those ideas clashing, and they kind of hold each other in like stasis. I was curious.
Yeah, no, that's well put. I guess I would say, I think that at least some defenders of a living constitution do it a disservice in that, and I don't think, for instance, if you think of sort of leading jurists, neither like the Justice Jackson or a Justice Kagan engage in this kind of argument at all, but where they say, it's kind of open-ended, and we update it, and updating it always turns out to mean that actually the Constitution means just what I want it to mean politically, and that's how you update it. And yeah, I agree, that's a real problem, because the Constitution doesn't always mean what you want it to mean. And it can do things that you don't actually like necessarily politically. And so I do think that version of living constitutionalism is problematic. I guess my worry is that originalism is, in some ways it can be, again, I'm not actually anti-originalist as opposed to sympathetic and skeptical. And I think sometimes it's incredibly helpful. Like you can actually, there's a pretty discernible one, and then we can think that we know what this means, and that could limit justices. I guess the question then is, do we, and that's where we're already like outside of the text in that way, because we're saying, okay, should we be bound by this particular original understanding? Why should we be bound by it? Why is limiting judicial discretion in that way? And I think those are all sort of defensible, but then you have to kind of make the argument for those that goes beyond the text and goes beyond even originalism there. And I do worry, and this is something that, again, students should take this up as a project. Originalists insist that justices are bound by original meaning, and that it limits judicial discretion. There's an argument of whether that's actually so, right? I mean, when they actually make their opinions, and when you courts are following it, does it really limit their discretion in that way? I mean, theoretically, you can see why it would, but does it? So I guess that's where I think it might be more elusive. And again, I think, I won't go over the arguments again, but I think it just rests, I think even then it rests on more unstated judgments. And I guess I think, maybe I'm wrong on this, but I think we'd be better off if we were clearer about our unstated assumptions, because they too often sound like, oh, we're just making a point that's obvious when it's actually not so obvious, depending on how you read it.
So I know I asked you a similar question this afternoon. I'm going to ask you
You didn't, the answer was obviously not satisfactory, right?
No, I think it was satisfactory. But to what extent do you think that the true Constitution that we rely on and operate on a day-to-day basis is sort of a conglomerate of conclusions drawn from political discourse and judicial opinions?
That's a really good question. I think a lot more of it than we tend to think, right? I think a lot of the Constitution, especially the parts we take for granted, is really based upon inherited understandings that were contested at the time they were contested for reasons that I think could be totally understandable. Like, right? I mean, so when you look at the text and when you look at the history about free speech in the 1790s, it's not at all clear that sort of the understanding that wins out, the Madisonian take that you've got to be able to criticize the government in powerful ways, was like just the natural or obvious reading, right? I mean, the other side had powerful reasons for thinking like they did. There was a whole common law inheritance. That had been the understanding of freedom of speech, while state constitutions like the Virginia constitutions had protections for freedom of speech before the First Amendment. Nobody really spelled out what that meant. So when you first got this kind of real criticism of it, it forced a question on us that it's not like the Chase and Iredell and like we're stupid. They're really smart. Thinking about it, they're working from inherited understandings in the same way. Like, I'll give you another one that I think is the biggest one we take for granted, although maybe I think we're actually maybe like, reopen this question. But, right, I mean, for most of my lifetime, the idea that states could secede from the Union was just like, you don't even, it's the equivalent of senators serve 6 years, right? That question's answered. That question is more, when you look back at the history, that question is more complex than we might make it out to be, right? I mean, there were lots of important political figures, including like Jefferson, making arguments against the Sedition Act in what's called the Kentucky Resolution at the time that kind of flirts with, I mean, at least puts forward a theory that would flirt with something like secession, right? That's answered not by the court, but by Lincoln, and Lincoln's insistence that actually I have to pick up arms to prohibit the states from seceding from the Union, right? And that's settled by way of political conflict and debate, and then ultimately, in that case, war. And we take that for granted. I think a lot of, when you actually look at American constitutional history, I think a lot of those debates really are framed that way, right? And this is where I say that it's not like we're just reading the text and drawing out kind of, oh, the meaning is latent in there, and all we have to do is bring it out. Read it, if we just read it just right, we just draw out what's already there, as opposed to, these questions force themselves on the political community. We have to wrestle with them. We wrestle with them. We come to certain understandings about them, and they're settled, at least for, sometimes forever, at least for quite some time. And I guess I would use that to try to say, I think that should, in an era that's really polarized and looks like things are awful that way. I mean, in the past we've been able to get through those periods, right? And then we reach kind of consensus on certain issues.
Okay, I believe that's all the time we have. Maybe Thor, you can talk with him after. Anyway, thank you again for coming. If you please join me one more time and thank you.
Yeah.